Stand by.
Attorney Lacy, have you been able to review the disc of the earlier portion of the hearing?
I have.
Are you satisfied with that?
I am.
You don't wish to call any of the previously called witnesses?
Not at this time.
You wish to call any witnesses yourself?
I do not.
You rest. Comments rested, you rest?
That's correct. Thank you.
Wish to be heard?
I do.
Go right ahead.
This is, I understand that he's here for a dangerousness hearing today, which of course he determined whether to be held without bail or not. There's some statutory requirements that have to be met prior to the judge ordering it to be held without bail. I'd like first to go over some of the information I've received, I've listened to on the disc this morning. I've been speaking to the witnesses, going over the police reports and so on. As you know, the allegation is that Ms. Paquette and Mr. Myers were in a dating relationship until Ms. Paquette testified until about fall of 2008, so about 6 months ago, maybe a little bit longer. Then she alleges they had dated for about 1.5 years, they were together, broke up about the fall of 2008. And in December 2008, she went and applied for a restraining order. And that restraining order was issued. There's some action that came out of that restraining order, including in this case that he has allegedly violated the restraining order on a number of occasions. On each of those particular occasions that he's alleged to have violated that restraining order, I'd ask the court to take into consideration based on the instances that it has before it. There's never been any actual physical violence. There's never been any actual touching of any sort. There's been before conversations of any of what performance of alleged to have occurred, but again, never anything physical. Nothing that ever culminated in a physical act. That was in December 2008, and then those are the events that occurred since. There's been a couple of alleged violations of that. Again, with no violence. Ms. Paquette testified that she saw Mr. Myers on the computer once in the fall of 2008 on a MySpace or Facebook login under the name of Jay. She testified that she saw that once, and that was according to her testimony that was given earlier. There's no other information from Ms. Paquette, from the keep of records, from anything else to indicate that Mr. Myers is in fact Jay. And quotes with a picture of some gentleman that is not Mr. Myers, and Ms. Paquette has been alleges that Mr. Myers has been using. I would say that Mr. Myers' connection to Jay is tenuous. I understand that's what Ms. Paquette has testified to that, but clearly there's a lot of other things going on here, and I would ask the court to look at that and see that it has not been proven, certainly beyond a reasonable doubt, but not even by a preponderance of the evidence, or it's more likely than not that he is this Jay person. Also, Your Honor, she had testified, Ms. Paquette had testified that she had received these threats on her own Facebook and MySpace account saying certain things, threats against her. She also testified that Mr. Myers did not have, she had changed, after they had broken up, she had changed her password. Mr. Myers did not have access to that password. She says he may have, when he was in her house on a previous occasion, may have gone into the computer and used it, but there's been no testimony to say when those were posted, the date of the posting, it was the same day that he was allegedly in the house, and he didn't have access via the password, and that was her testimony related to that. She also had testified that, I'm sorry, there was also police reports and other things that came in via Concord. The acting police, I think, had taken some reports of him allegedly having appeared at work at her place of employment. Again, no physical acts, but again, he had appeared. That case has not been tried. Mr. Myers is taken out to trial. He doesn't contest his facts. That report came in as an exhibit here. There was no cross-examination of any police officer or anything else. That's a hearsay document under any other circumstances. I understand the evidentiary rules don't necessarily apply to these types of hearings. But again, that's been an allegation made by Ms. Paquette that's not been subject to any type of cross-examination or anything else at this point. We don't know what's going to happen with that case in Congress. But again, she did not allege there was any physical acts or violence. There was nothing that he had done to touch her or hurt her. If he had done what she said he had done with someone, he scared her. But that would have been, again, nothing, no violence. She goes on, and she testifies that he'd been in her house and some of these other things. There's a record that was submitted. He did plead guilty to violation of abuse of professional order in the last case that I wrote something. In that case, alleged he was in the house. But again, didn't hurt her, didn't threaten her physically, asked to speak to her and so on. So, Your Honor, the evidence that we have today is the Facebook postings on Ms. Kat's account, on Jay's account. Those are the two pieces of evidence. We have the police reports. All these things, Your Honor, again, are unsubstantiated, and I ask the court to take that into consideration. Then we turn to the sister. The sister testified that she's been receiving these texts back and forth from Joe. And Joe is how she recognizes her brother on the telephone through the text services. She says that this is Joe, but she also told Attorney Krieger, who was doing the cross-examination at that point, that she just knows it's him. There's no other identifying information in this house. There's also been no testimony that, I believe there was some testimony that part of the threat that was allegedly made by my client was there was a bomb. The events that occurred between the sister and Mr. Myers were several days prior, I think, to his arrest. And in the meantime, there's not been any discovery of any bombs. Supposedly Mr. Myers said he made a bomb. He's going to do certain things with the bomb, but there's not been any bomb discovered. So if he did in fact say those things, there was no physical act that was performed to back up whatever he said he was going to do. And certainly he had time to do those things. He didn't do that. The sister also testified that there was no photos or any other identifying information. It just came from his Joe. So whether somebody had access to his phone or his previous identification to get to her phone, we don't know. There's no identifying information other than this bare Joe that says it was Mr. Myers contacting her. With all the evidence as it stands, Your Honor, I'm asking the court to rule that there is not sufficient evidence to find he's a danger that has to be held without fail. It also has the court to consider that the statute requires that there be no other condition of release that can be imposed on Mr. Myers that would satisfy his requirement to come back to court and assure the safety of the person against whom the special made. Your Honor, all these, I would suggest that there are conditions that can be imposed on Mr. Myers. As you know, he was held on a previous case. He has recently been released. There's conditions of him going to see therapists, going to work, finding a place of employment, finding a home, staying away from his cat, not having access to computers, not using cell phones. Because all these communications occurred electronically and remotely. He didn't come to her house and so on. I would suggest that there's many conditions that could be imposed that would assure those two requirements in the statute that Mr. Myers would not have to be held without bail under the statute. Now that's the court to take that into consideration as well.
Attorney LACY, am I not incorrect?
Just looking at the defendant's record, which is submitted as an exhibit pursuant to the evidentiary hearings, the defendant does have a history of prior convictions on that record, which is a condition under the statute. The Commonwealth would suggest Section 5 of the 58A statute. I have an individual that had previously been on probation for assault back in 2005. There was a violation of that probation. He was given a 90-day committed sentence on that matter. Then he had a dating relationship with Ms. Paquette in this case, of which he did get a 209A order, which is still currently in effect, which is another condition that the court suggested to look at pursuant to Section 5 of that statute. We have the report that the Commonwealth submitted out of the pertaining to the Concord matter that's going to the Concord District Court. And the affidavit attached to that 209A order indicating Ms. Paquette's statement to the court at that particular time involving that incident, the defendant approaching her and not letting her leave, attempting to take her keys, starting off in a pattern of conduct, Judge. Then you have the docket entry that the Commonwealth furthermore entered on the last page, that indicating when the defendant was before this court on charges of breaking and entering into the Paquette residence, intimidating a witness, and violating that order, which this court very fairly gave the defendant probationary terms therein. Again, the defendant being on probation at that point in time when he left this court June 10th, 2009, another condition that the court could look at pursuant to that section of the statute. And not just a couple days after that, when the defendant leaves this court, do these text messages via MySpace and Facebook begin to occur, where Ms. Paquette receives one from this individual with a symbol of J, with a picture that Ms. Paquette recognized to be coming from the defendant. She saw him under that indication at one point in time, of which this indication says that she's going to get it. Sorry it has to be like this, but it is coming. And you also heard from the defendant's own sister, she received some text messages via MySpace as well, going back and forth with her brother, indicating to the court that the only individual she knew was Joe was her brother. The only symbol she recognized as coming from this individual was that of her brother. Very curiously, in that correspondence that she recognized to be from her brother, does the individual make reference to a 4-month jail sentence, which just happens to be the amount of time that the defendant did stay in jail, indicating that he was going to do harm to a warrant, the individual that put him in jail, indicating that she was dead, quote unquote. The next time he goes to jail is going to be for life at that point. All these indicated from an individual she knew to be her brother as she testified before the court. So what the Commonwealth would suggest is you have a pattern of conduct here where the defendant, just being released from the court, goes out and just completely disregards what the court had asked the defendant to do. Been on probation at this time, been on probation in the past, just has not abided by any conditions. So I don't think there is any reassurance that if the defendant were released in any event, that he would abide by any conditions that the court would impose. And furthermore, pertaining to the pipe that was found in the bag, there was no further indication clearly presented at the hearing that the officer could indicate it was part of a device that could be built into a bomb. However, the defendant, we would suggest that the defendant would stop before it would become a reality, as he indicated in those text messages that that was his intent to begin on this bomb-making material, and I would suggest he was just luckily pursuant to the police. They stopped him before any further difficulties could result. So again, in conclusion, the Commonwealth would just suggest there are no conditions of release that would assure the safety of Ms. Paquette, her family, or any other member of the community based on the defendant's actions here and the defendant's prior actions contained on his record, as well as the incident in the Concord area. And for that, those reasons, I'd ask that the defendant be held.